I regularly get asked about boundary disputes between neighbours. Sometimes the question is, where does the actual boundary lie between one person's property and the other? Sometimes the question is, if there is a boundary, a wall or a fence, or etc., who owns it? Do both own it jointly, or does one party own it? Sometimes it's about trees, for example, overhanging somebody's property, overhanging somebody else's property, and liable maybe to cause damage, or there's a fear they might cause damage. Sometimes it's to do with roots of trees that go under a boundary wall from one person's land. The one thing I've learned to tell everybody about boundary disputes is they can get resolved ultimately in court, but please consider all other options before you go to court, because boundary disputes are just not worth. In the vast majority of cases, they're not worth the time and the hassle, and particularly the expense of going to court. I just want to read a quotation from a judgment recently of a senior judge about boundary disputes and about the futility of bringing them certainly to the higher courts. He says, boundary disputes are a particularly painful form of litigation. Feelings run high and disproportionate amounts of money are spent. Claims to small and valueless pieces of land are pressed with the zeal of Fortinbras's army. And the reference to Fortinbras's army is a quotation from Shakespeare's Hamlet, where Fortinbras is advised not to commit his army to fighting a battle for a piece of ground that won't be sufficient to bury all the dead who finish up dead as a result of the battle. So please try to avoid going to court. Now, under Irish law at present, if somebody comes to a solicitor with a view to taking a case to court, the solicitor is obliged to point out that there is an alternative dispute resolution system in place, namely arbitration or conciliation. And that, I suspect that a lot of lawyers will see themselves losing money, if people decide to go in that direction. But that does not relieve them of the responsibility of telling them and being honest and objective about it. And if anybody puts that case to their solicitor, asks them about the alternative dispute resolution, and the solicitor says no, that it's not possible in this particular case, I'd like to hear from those people, because I suspect that there's quite a bit of this going on. So basically, when you're considering any type of dispute in relation to land or boundaries, you have to consider a number of things. First of all, how does the position of this boundary affect the value of your own land? Are there any long-term consequences for your land, for the sale of your land in the future, your property in the future, if this thing isn't resolved? You must also take into account the fact that if there is an ongoing dispute, and at some stage you want to sell, what effect this dispute will have on the value of your own property. Now, normally, if this thing has to go to court, normally it will go to the High Court, the Supreme Court, the Circuit Court, the Circuit Court or the High Court, both of which are pretty horrendously expensive. Now, the cheapest court in Ireland for litigation is, of course, the lowest court, which is the District Court. Now, there's one particular situation in which these things, if they can't be resolved by arbitration or by conciliation, they can be resolved at District Court level. And it relates to a particular situation where one party, if two people are adjoining each other and there's a boundary between them, if one of the parties want to do some work to the boundary, let's assume it's a boundary wall or something, for safety or whatever reason on their own side, and the other party doesn't agree, the person who wants to do the work can apply to the District Court for what's called a works order under Section 45 of the Land and Conveyancing Act of 2009. That's a much cheaper procedure, I can assure you, than having something just fought out in the Circuit Court or the High Court. Again, I would counsel everybody, or I would advise everybody, to try to settle this by arbitration. First of all, amicably if at all possible. Secondly, by arbitration or conciliation. But if you have to go to court in relation to a particular boundary dispute like this, where you feel you must do something to the boundary wall or whatever, to secure the value of your own property, or to maybe make the wall safer or whatever, and the other party doesn't agree, you can look for a works order under Section 45. Now, in that situation, the district court judge has wide discretion. For example, let's assume you have two people, boundary between them. One of them wants let's say it's a wall. One of them wants to repair the wall. The other person feels that it'll do some damage. It may be necessary to repair the wall, but from the other point of view, the guy on the other side may feel it'll do some damage. It'll cost him some money. In that sort of situation, the district court is enabled to make an order for compensation for whatever damage the other person suffers, or whatever expense they have to undergo as a result. So district court has huge, very wide discretion in a case like that, and it's a much cheaper and much more efficient system than trudging along to the circuit court or the high court and spending inordinate amounts of cash for something that's in many cases of very little value.